Appeals Division 1 is now in session.
Morning. Please be seated. This is the time set for oral argument in Ian against Whitehead. Our cause number 1CA SA 17-0085. Counsel, as I hope you're aware, we have thoroughly read the briefs and conferenced the case before coming in this morning, so you may bear that in mind as you begin your presentations. We will be audio and video recorded today, and those recordings will be made available online for your viewing pleasure and that of the general public. Each side has 20 minutes for argument. Petitioner, you may reserve as much time as you wish for rebuttal, but you are responsible for watching your own clock. With that, if you're prepared to begin.
Thank you. May it please the court. My name is Carissa Seidel, and I represent the petitioner, Hannah Ian. Your Honors, this matter stems from an interlocutory order resulting from a motion in limine granted prior to a sharp hearing, which precludes wife from introducing evidence of the parties' settlement and from introducing the contributing evidence of the testimony of husband's former counsel surrounding the settlement. This evidence is crucial, dispositive, written, and oral evidence that establishes the existence of the parties' agreement. This court should accept jurisdiction because as pretrial evidentiary rulings, the challenged orders are interlocutory in nature. The trial court, in granting husband's motion in limine, proceeded without legal authority and abused its discretion in ignoring this court's decision in Murray v. Murray, as well as this court's decision in, and I apologize if I mispronounce this, Acamazo v. Kemp. Rule 69 and Rule 408, Rule 69 of the Arizona Rules of Family Law Procedure and Rule 408 of the Arizona Rules of Evidence bring us here today. Rule 69 is quite straightforward. As it's currently written, it states that an agreement between the parties shall be binding if the agreement is in writing. Rule 69 does not require that the writing contain the words Rule 69, or that the writing be signed by the parties, or that all issues even be resolved. Rule 69 can be one issue, or it can be all of the issues, or any number of issues in between.
Is it similar to the Civil Rule 80D?
It is almost identical to Civil Rule 80D, yes. And in fact, the case law prior to Murray, because Murray is the first family court decision directly on point, the case law prior was relying upon Rule 80D, and I believe that this court, in ruling on Murray versus Murray, did address the similarities of 80D and Rule 69.
What's your position on the question of if there's some type of disclaiming language in an email? There's a writing, but the email, there's a disclaimer that says you can't use this in any proceeding.
Correct. So just like any settlement negotiation that is drafted, that is sent between attorneys, there is always going to be settlement language contained at the top that says something along the lines of this communication is protected pursuant to Arizona Rules of Evidence 408, and then they contain all sorts of different language. Specifically, the language in this case, husband is trying to argue that it somehow is more broad or gives an added protection. In fact, I believe that husband has argued that under some contract or promissory estoppel theory, that by putting Rule 408 language into the settlement communication, that we somehow asked for a greater protection than Rule 408. But wife never intended to enter into an agreement that husband could then back out of in reliance upon that same language. So husband says the emails and the letters that contain the Rule 408 language are precluded from admission at the court. And the trial court has in fact said that. However, husband is then arguing that this Rule 408 language creates a new additional contract between the parties. Well, how is the trial court going to determine if a contract was reached as to the Rule 408 language, which is at the top of each of the communications, if the trial court can't look at those emails and look at those communications and see, and then ask wife, did you intend to be bound by this agreement? Because I can avow to this court and to the trial court that wife never intended to be bound by that agreement. Rule 408...
I'm sorry, by the agreement that
The agreement that the parties reached, the full and final settlement that the parties reached. And wife did not agree to be bound by the Rule 408 language.
Oh.
The Rule 408 language, Your Honor, sorry, I don't think I was very clear. The Rule 408 language is specifically to protect parties who try to back out of settlements, or who, when settlement negotiations fail. When settlement negotiations fail, we all know you can't introduce that communication, that email, that letter, in order to prove the claims in the letter. But that's not what we're trying to introduce these documents for. We're trying to introduce them pursuant to Sharp, which contemplates that a written agreement would be admissible as evidence, and pursuant to Rule 408, that this is evidence that a settlement itself was reached. And how else can we prove that an agreement was reached in writing, which is what Rule 69 requires, if we cannot admit the documents that show that an agreement was reached?
So do I understand your argument to be that taking that interpretation of the language to say it could go beyond 408 would undercut the purpose of Rule 69, because the parties could reach an agreement under Rule 69, would then be precluded by Rule 408 from showing it?
Correct.
Or not by 408, but by that interpretation of saying you can't use this for any purpose, which would undercut the purpose of Rule 69.
Correct. It
Okay.
absolutely undercuts all of the established case law. Rule 408, Rule 69, the decision in Sharp v. Sharp, the decision in Murray versus Murray, the decision, obviously I want to go into Alcamazo as well. There's also a separate issue, which is the waiver of attorney-client privilege.
Well, let me get to that for a second.
Sure.
I was looking at this, as a matter of fact, last night and this morning, and so let me pose this hypothetical to you. Let's assume, hypothetically, that we said, yes, these emails are admissible for the purpose of the hearing. And then let's assume, hypothetically, the judge says the letters, the trial judge says, the letters do show what I think is an agreement.
Correct.
Under Rule 69. And Mr. Myers argues, I never authorized that. Isn't there an argument that, and you want to be able to, if he does that, you want to use the attorney's testimony to show he had actual authority. But isn't there an argument that under Robertson versus Ailing, the Supreme Court decision in 2015, that based on these communications, there could have been apparent authority, regardless of whether Mr. Meyer authorized it or not?
Based upon which communications, Your Honor?
In other words, the emails exchanged.
Okay.
If they're, because they're copied to Mr. Meyer.
Correct.
Technically, it's possible if all my hypotheticals spun out and the judge said, yes, the emails come in, we say the emails come in, judge says, okay, I find there was an agreement. Mr. Meyer says, yeah, but I never authorized my attorney to do that. That the court could say it doesn't matter because it's possible that the testimony of the attorney wouldn't be necessary because the communications themselves amounted to an apparent authority?
I believe that absolutely that the court would have that ability without the testimony of husband's former counsel.
Okay, because that would only, husband's prior attorney's testimony would only go to actual authority.
Correct.
Okay.
Correct.
All right.
In addition, we also have asked for the billing records, and we have seen the billing records, and husband's making a claim that somehow those billing records are attorney-client privilege. Well, there's never been a decision of this court that I'm aware of, or any court, that has entered a finding that billing records are attorney-client privilege, because I believe that the billing records would also present another form of evidence to show that husband's former counsel communicated with husband on that day. Her letters, her emails indicate, I just spoke with Joseph, and based upon our discussion, or based upon the issues outlined below, we have a full agreement. So under Akamazo, the concern here is that husband has asserted that his attorney acted without his authority, that they did not have a full settlement, and then the attorney entered into a settlement, said we have a full settlement, said please draft the paperwork that evidences this entire settlement, and then months later, husband is able to say, wait a minute, never mind, I no longer agree with
So
what's being
this is the sword and shield argument.
correct,
Okay.
correct.
But again, trial court might not have to get to that.
They may not have to get to that, I agree with you. But I think that under Rule 401 of the Arizona Rules of Evidence, this evidence is relevant, and because the trial court is also tasked with determining the credibility of the parties, credibility comes into play here as well. And one of the issues that the court is also going to look at is reasonableness of the positions. And the trial court has already opined that if one of the parties has been unreasonable under ARS Section 25324, that the court may award attorney's fees. And that would be another issue that the court could look at to say, was husband reasonable in asserting that his attorney didn't have authority to enter into this agreement, when in fact his attorney will testify that she did have authority to enter into the agreement, and that he frankly backed out of the agreement at a later time after consulting with new counsel.
Assuming there was an agreement.
Assuming there was an agreement, yes, but the evidence, which again we are asking the trial court to consider, shows that there was an agreement.
Okay.
The other argument that I want to go back to make sure that it's fully examined is this argument about a contract contained within the same communications, the same emails that husband is trying to keep out, and the trial court has said don't come in. So he's saying under contract principles and promissory estoppel that a contract was formed in this Rule 408 language. But essentially what that allows litigants to do is to pick and choose parts of the contract. Well, I like this language, but I don't like this language. And then say, I like this language, but I don't like this language. But Judge, you can't see it. And you can't see it because we agreed to this 408 language. But again, husband's putting something into wife's mouth that wife never intended. Again, wife only intended not to present the evidence if settlement failed. And again, we need to, the court here needs to be reminded of settlement is a public policy of Arizona. And what husband is asking this court to do is ignore public policy, ignore Murray, which specifically allows for this evidence to come in before the trial court, to ignore Acamazo. There's already a trial court finding that attorney-client privilege has been waived. And based upon that finding, and based upon husband's contrary assertions, we have contravening evidence that could come in from the former counsel that states that an agreement was in fact reached. Another issue is that we have wasted an inordinate amount of judicial resources on this case. We filed the motion to enforce the Rule 69 agreement almost 1 year ago today. And since that time, we have had 3 half-day evidentiary hearings scheduled before Judge Whitehead. All of those hearings have been vacated. And if a Rule 69 agreement is found at the final sharp hearing that we're hoping to have, we don't have any further hearings in this case. We don't waste any more judicial resources. If we go to the Rule 69 hearing and Judge Whitehead concludes that no Rule 69 agreement was reached, or that a Rule 69 agreement was reached, but it should be set aside because of fraud or duress or coercion or some other argument that husband might make, then we actually have to come back and probably have a 1 to 2 day trial in front of Judge Whitehead on all of the issues. Because right now, as it stands, the agreement resolved spousal maintenance and the majority of property and debts that are at issue.
I'm sorry, what I may have missed this, but what's your point about the spending of judicial resources?
Well, Arizona promotes settlement, and Arizona obviously does not favor a waste of judicial resources.
Okay.
I'd like to remind the court that husband affirmatively placed privileged communications at issue in stating in his deposition that his attorney acted without authority, and in his deposition against sworn oath stating that an agreement had not been reached. Acamazo versus Kemp found that affirmatively placing privileged communications at issue waives the attorney-client privilege. Case law also states that waiver can be either implicit or explicit, but asserting wrongful conduct against a lawyer, the client impliedly waives privilege. Wife is prejudiced right now as it sits. For the last year, we have been litigating whether a Rule 69 agreement was reached. We have evidence that absolutely confirms that an agreement was in fact reached. Husband will argue that it wasn't a full agreement, but again, that's not what Rule 69 requires. Rule 69 only requires that it be in writing, and this is an agreement that was in writing. Rule 408, Murray specifically allows for the introduction of this evidence at the trial court. And I'd like to reserve a couple minutes at the end, Your Honor.
Very well. Thank you.
Good morning, Your Honors. Thank you for taking the time to hear our case. My name is Brian Easton. I am the attorney for the real party in interest, Joseph Mayer. I want to get, first of all, if I might, to, I know you've briefed everything and reviewed all the briefs, so I'm going to just address, what, if I can, some of the comments that were made in the reply brief filed by the petitioner. One of the things that prompted me to ask for oral argument today was the reliance by petitioner on Rhodes versus Avon Products, which is a case that they have not addressed in their preliminary petition. And they cite to this case in support of the fact that here is a Rule 408, a case that involves a Rule 408 kind of issue, and that the parties were engaged in settlement discussions of some sort over a period of time, and that this case somehow supports what is happening here, and that is not the case at all. This case that they rely on, Rhodes versus Avon Products, is distinguishable on the facts. Only one party sent a letter under Rule 408, according to the case law, and made a claim that in that letter that nothing would be admissible, and that is very different than what we have here. The other party in Avon did not agree to either the Rule 408 claim or that the letter would be admissible for any purpose.
But if you invoke Rule 408, don't you have to live by the terms of Rule 408? Or are you suggesting that somehow the exchange of communications here wrote a different rule that is broader than Rule 408?
I don't think they wrote an addition. I don't think they wrote a broader rule, Your Honor. I think they wrote an additional rule, and that's what we've argued throughout. Is that the language that was invoked by petitioner's counsel was that this is Rule 408 protected, and they actually used the word additionally.
Well, would you agree that if all you had was Rule 408, Rule 408 does not prevent admission of communications to establish the existence of an agreement?
Yes.
Okay.
If you only have Rule 408, yes. So
Rule 408 doesn't help at all here. So really all we're concerned with is the additional stuff.
Yes.
Okay. So where do we see anything in the language that reflects a meeting of the minds on the precise contours of a rule that doesn't exist in the book?
Well, it's a rule that exists in terms of promissory estoppel, Your Honor. The parties made an agreement at the very beginning that they would not use these exchanges, these email exchanges, for any purpose. And that is seen in the opening email from wife's counsel on November 18th, where in addition to the caption at the top where he says Rule 408 protected, he says in the body of this email, all of the contents of this letter and any discussion we have regarding it shall constitute inadmissible settlement negotiations which are not to be introduced at any trial or hearing this case.
But you can't just declare that, right? I mean, if I'm not saying you would do this, but if a lawyer decides to write heinously nasty letters to opposing counsel and simply declares at the outset that nothing in this letter can be used in the eventual motion for sanctions, we wouldn't honor that, right?
I don't know whether you would or not. I would think
I can promise you we wouldn't. You can't simply create a cloak of secrecy by declaring it. And so then you have to. I understand the language that you just read, but then the language that gets sent back is not all-encompassing or unconditional. The language that gets sent back says, we can use this to show the reasonable of positions. And ultimately, it strikes me that this is sort of the party's boilerplate, but not a negotiated agreement.
I would disagree with that, Your Honor. I think, number one, what was sent by Petitioner's Counsel, and I didn't get to read the full contents of what was said, but he goes on from where I was cut off, it says, additionally, neither this letter itself nor the information set forth in this letter shall be admissible in any further proceedings in this matter. That's the opening letter. Then the response that comes from Mr. Mayor's counsel says, please note that this counteroffer settlement is being remitted pursuant to Rule 408 of Rules of Evidence, and nothing contained in herein will be admissible, absent argues for, to show the reasonableness of the party's position, showing an agreement between the two parties that none of those emails would ever be used for any purpose in any way.
I guess I'm having trouble getting to an agreement. Neither prefatory language says anything about the other party's communications. All it does is say, this is my communication, here's how I want to restrict its use. It never has me agreeing to what I'm going to do with your communications. It never reflects an agreement between the parties that we are engaged in a process by which none of our communications will be entitled to admissibility. Right. So the first letter from wife's attorney doesn't say anything about what happens to husband's communications. And so how is that mutual? How is that an agreement? It sounds more like a proclamation to me of dubious enforceability unless you can rely on the rule, and we've already established that the rule doesn't help you.
I beg to disagree.
I expect you to, but I want you to take me through the reasoning as to why these unilateral proclamations to create an agreement.
Well, I don't think they're unilateral proclamations. I think they are statements that are being relied on very forcibly by both opposing counsels. If I were to say to you, I won't use any of this information in a later proceeding, and then you proceed to dialogue with me and basically waive your rights because you're beginning to share information that might otherwise be protected. If I can't rely on that statement, then I have just waived that right. So even if it is a universal proclamation, or a unilateral proclamation, Your Honor, I would argue that I have the right to rely on that. And if I come back and say the same thing back to the other side, if I proclaim to them that I'm going to agree to myself, I'm going to hold myself to this standard, that I will not use this in any further proceedings, and what you're trying to do is get to the fact that you're trying to have a free exchange of information so you can put together settlement proposals that are going to make this thing work. And then the party comes back later and says, you know what, it didn't matter what I said. That just strikes me as incredibly disingenuous and saying that, hey, we're just going to say that, well, the rule says I can come in and say that, and you should have known that.
Well, perhaps, but I guess what concerns me a little bit is we have a rule that is designed to cover such communications. The rule here doesn't resolve this dispute. And now we have a suggestion that by including these statements in a letter, we can essentially rewrite the rule based on a traditional broad doctrine of promissory estoppel. So I'm curious if you have found any case in Arizona, any of the other 49 states, or the federal courts where that has happened to restrict admissibility beyond the scope of Rule 408.
Well, there were a number of case sites I made in arguing that the court below, and remember, Your Honor, what we're here for is an abuse of discretion, okay? They have to prove evidence that the court completely disregarded Murray and any other case law or applicable law that might be relevant. So what I tried to point out in my brief was that there are other case law, other legal theories that support what the court below did, or could support what the court below did.
I know, but I guess my question's a little different. Have you found a case on point that says that this prefatory language in a letter can be given effect according to its terms beyond the scope of Rule 408? Because I haven't seen such a case.
Well, I argued in the portion where I addressed stipulation that the court below could have viewed this as a stipulation. And the case law cited there actually does talk very forcefully about the fact that if the court below found this to be a stipulation, that the court would have to honor it. For instance, under Rutledge versus Board of Regents, which I cited to, it's an Arizona case, 1985, appellate decision. A stipulation is an agreement, admission, or concession made in the judicial proceedings by the parties or their attorneys in respect to some matter incident to the pleadings.
I understand, and I get it. I love stipulations. I'm all for as many stipulations as possible, but they have to be actual stipulations. I have not seen a case that says that this language sort of passing in the night creates a stipulation. It doesn't even strike me that the language in either party's letter was designed to create a stipulation. It never invites acceptance. It simply says, this is my position. And then two positions come across each other, which are related in some ways, but different in others. How do we get a stipulation out of that?
Your Honor, again, if it's not a stipulation, it's promissory estoppel. If it's not promissory estoppel, it's a contract. There might be other legal theories. What I'm trying to point out is that the court below could have reasoned that there was something here that allowed this to happen. I don't know what the court below based its decision on, but I do know that the court below had extensive briefing on this. It was contained in both parties' pretrial statements. I brought a motion in limine on it. The court invited briefing, which was briefed by both sides. After that, a motion for new trial came. So the court below had some consideration. I don't know what it is. But is it a stipulation? Maybe, because I think that the parties had some kind of agreement here, some understanding that they were going to begin exchanging it. And they both acknowledged this. And my client, for sure, with his attorney.
But shouldn't there have been some sort of stipulation that this will not be used to prove the existence of a settlement agreement? Since that's something that attorneys understand is part of our law, that you can prove the existence of an agreement. It's different than using substantively what's in the proposal. If you go to trial and you've withdrawn from the agreement, it's clear, and I think the boilerplate goes to that you can't use this for some purpose if we go to trial. But since everyone's aware that there is this provision that if we have the existence of an agreement that's in writing, it seems like your position just does away with that rule. If you can just say, oh, we've got some boilerplate here, even though we didn't specifically reference the ability to show the existence of an agreement in writing. You've just written that out of our law.
I don't see that, Your Honor. I don't see that we're rewriting the law here. What I think we're seeing here is just supplementary principles to Rule 408 and to Murray. And in this case, the statement by opposing parties' counsel was that this email and any emails discussing this afterwards will not be used in any hearing for any purpose.
Counsel,
that's broad.
It does seem to me that interpretation would undercut the whole purpose of settlement negotiations. And to the extent that Arizona public policy is to encourage settlement, and Arizona public policy is we don't want a lot of litigation over whether there was a settlement or not. And so the case law is essentially, listen, if the exchange of correspondence can reflect, or does reflect an agreement, that correspondence should come in to show that. And what you're saying now is, if I understand your argument is, well, we can do away with all that and get both sides to say, listen, this isn't going to come in for any purpose, including proving that we ever reached a settlement. And then the two parties do reach a settlement, and the last minute, I'm not saying this happened in this case, but if you take it to its logical conclusion, one of the clients gets buyer's remorse and says, I was going to sign it, and I'm not going to sign it anymore. Nothing the other side can do. There's just nothing, because they can't bring in, because the parties agreed, all this correspondence could never be used even for the purpose of proving a settlement. That would allow a person at the last minute to basically say, I know we just went through 6 months of negotiations and attorney's time and attorney's fees, but I'm not going to do it anymore. And the other side has no recourse. Doesn't that strike you as?
Under your hypothetical, I would agree that that's possible, but that's because at the outset they would have agreed that this would not be admissible evidence. If they have that agreement up front, I think they can do that.
But it undercuts the whole purpose. It undercuts public policy, doesn't it? Because the public policy is to encourage settlement discussions, encourage settlement, and to avoid a lot of litigation about whether there was a settlement or not.
No, I don't.
That's not the public policy.
No, I don't think it undercuts public policy.
Okay, why not?
Because I think it encourages the freer discussion of settlement proposals. That's exactly what happened here.
But Rule 408 does that by itself. I mean, the rules do that by saying anything that's discussed in negotiations is not going to be admissible in evidence to prove, so it can be used against the client, except for that there was a settlement.
Well, then you're just arguing that the agreement is somehow coextensive in terms of the effect that Rule 408 might have. Mm-hmm. But if it's coextensive, then it doesn't undercut it. So I mean.
Well, but you're saying it's broader than Rule 408.
Yeah, if it's more extensive, then it doesn't help because we've already agreed that Rule 408 doesn't go far enough to support your position.
I'm saying it's supplemental too. I'm arguing. I'm replying to Judge Kessler's hypothetical that if for some reason you make this agreement and you perceive that this agreement ahead of time that you will not admit it for any purpose, that somehow it is it's already covered by Rule 408. Well, that argument kind of breaks down because Rule 408 already says you can't bring it in.
But the rules do allow, and the case law does allow you to use the emails exchanges and have them admissible for purposes of showing there was an agreement.
Yeah, no, I agree that's what Rule 408 says and even what Murray says. But I think that there's, and I've talked about stipulations here, but there's also the issue of contract and promissory estoppel. So if a party reasonably relies on information on that statement, they have waived a position. They have given up the right to a right and in reliance upon what is stated. Additionally with contract issues.
But that kind of assumes that if there were language, I might be inclined to, or I would find some logic in what you're saying. If there's an agreement, the boilerplate language says this cannot be used to prove the existence of an agreement, and both sides put that in their correspondence. That would be something different. It would be kind of nonsensical, and I don't know why people would do that. But that's not the boilerplate language at issue here. There isn't a reference to proving the existence of an agreement.
No, but there's just a reference that we will not use anything at all that in these email exchanges for any hearing.
Let me ask you.
That's pretty broad. I mean, it covers that.
So your promissory estoppel theory then is that by continuing to talk, one accepts the command of the language in the letter. Is that basically right? By continuing to communicate. Okay. So if I write you a letter, we're opposing counsel, and I write you a letter saying this is a Rule 408 settlement communication. There will be no admissibility, any further communication constitutes a waiver of your right to legal decision making over your children. And you respond to me, have I got you? Did I just win the custody issues in the case?
I don't think so, unless you come back and state your agreement towards those. And my
what if I'm silent about those conditions, but I just say I'd really like to discuss the gray metal chair, and we talk about that. But I've continued to speak to you now under these onerous conditions that you broadcast as boilerplate. I don't think promissory estoppel means I've agreed to everything you declared just because I continue to talk to you.
No, but if I come back and specifically say I do agree to a particular condition, then I think you do. So
but they didn't do that.
Well, they did do that, Your Honor. They came back and said that we agreed to, let me see, the response from opposing counsel was that she came back with her own counteroffer, or with a counteroffer that says, please note this counteroffer of settlement is being remitted pursuant to Rule 408 of the Rules of Evidence, and nothing contained in here will be admissible.
Unless, except,
are used to show reasonableness of the party's position.
Right. So they're right there. You have basically a rejection, right? Isn't that a counteroffer? assuming for a moment that any of this represents a contractual negotiation, wouldn't that be a counteroffer and thereby a rejection?
No, I disagree with that. I think you have both parties agreeing to the principle that the email exchanges that are going on are not admissible. I mean, even opposing counsel is arguing that you don't have to have agreement on every last thing. And what was agreed to here by both sides, they both stated it, they both agreed to it, is that this email exchange and any communications related to it would not be admissible for any purpose. And Your Honor, let me, because I only have 20 seconds left, I just got to go back and say Akamatsu is not on point. What they're quoting the language for is incorrect. You have to have my client acting more than just saying, I disagree that there was an agreement entered into in order to get to attorney-client privileged communications. That didn't happen here. He didn't, Akamatsu stands for the proposition that you have to lie, you have to take what the counsel told you and then frame your position based on that and argue that it was reasonable because of that. And that didn't happen here. He just said, I don't know if she had the right to enter into it, so that's just saying I don't know.
Okay.
And
Counsel, I'm going to ask you, and I don't want to unnecessarily detain you, but I want to ask you the same question I asked your opposing counsel. Let's assume that we say the emails are admissible for purposes. The emails are admissible. We assume that we say the emails are admissible for purposes of proving whether there was an agreement, and the trial court admits them and says, I think there was an agreement, and your client. You then argue, yes, but the attorney never had authority to enter into that agreement. Wouldn't the trial court then be able to either consider whether the attorney had apparent authority under the Robertson case or admit the testimony of the attorney to dispute what your client argued about authority?
I think I'm going to say that that is not possible under the circumstances in this case, Your Honor. And here's the reason why. We have not alleged anywhere in our pretrial statement that my client's former counsel lacked authority. All he ever claimed in his deposition was, I don't know if she had authority. That's just that he doesn't know the law.
But my premise was that you got up and argued after the court said it looks like this has an agreement. This is an agreement. You took the position, gee, Judge, that attorney never had the authority to do it. Assuming that, I'm not saying you will do that, but assuming you did that, your client said, I want to take that position, and you did it. Would the court then be able to say, okay, either we're going to admit that either one, I'm going to consider whether there was apparent authority under Robertson, or we will consider the evidence from the attorney about whether he had authority?
I would, again, Your Honor, I would say that we have waived the right to bring that because we have not included in our pretrial statement. There's case law which says that if you don't put it in the pretrial statement, it's waived. So we can't bring that argument. Just can't. But if you ask me to answer your hypothetical directly, I would say yes, the apparent authority argument would stand. But we cannot bring it because we've already waived it on pretrial.
So you're saying that you have waived the position that your attorney did not have, the prior attorney did not have authority.
We've never made that claim in the first instance.
But you're saying, so you're not going to assert it. You're binding yourself to that.
We're binding ourselves.
Right.
We're not asserting that the prior attorney lacked authority. That's never been our position. It was just they took some language out of the deposition transcript that seemed to go to that, but it didn't. It was just my client saying, I don't know. I don't know.
Okay.
Shit.
So,
he's not aware.
So you're conceding that point. You're not going to do that. You're not going to argue below. If we came down and said the emails come in are admissible, the judge says, I think the emails show an agreement, you're not going to take the position that the attorney did not have authority to enter into that agreement.
That is absolutely true.
Okay.
Thank you very much.
Thank you.
So in response to that concession, do you need the testimony of the attorney or the billing records, except maybe to show attorney's fees or reasonableness of position or whatever? Do you need the admission of the testimony of the attorney to show that he had authority?
With that concession, Your Honor, I believe the testimony and the evidence is still relevant. And I believe that we could get by without it. I believe that we can be successful at the trial court level without it.
How is it anything other than cumulative?
And I agree with you, Your Honor. The only issue would be if husband does take the stand and maybe he's not bound by his agent here today.
So in other words, you're saying that he might say, "I never gave my attorney authority to make that concession."
Absolutely, he's
Right.
done it before. So, Your Honor, Your Honors, I would ask that this court accept jurisdiction and grant the requested relief. I want to point out, just address a couple of the arguments that were raised real quickly. Your Honor, Catani's argument about the boilerplate language. This whole argument goes to what do we as attorneys use as boilerplate. I've seen as little as this communication is subject to Rule 408. I've seen even less than that. This email is pursuant to 408, not even where that comes from. So are we asking that attorneys have to build in some additional, very, very detailed boilerplate language? And are we essentially asserting that there's two contracts if an agreement is reached? There's a contract regarding what's admissible, and there's a separate contract regarding the agreement.
I think the idea behind Rule 408 is that you don't need a contract.
Exactly.
You can simply send a settlement proposal, no matter how out of the blue or wacky, and it's covered by Rule 408. It may get ignored, but Rule 408 still applies. The argument here is that there's something beyond Rule 408 because there was an exchange of language that really, to some measure, conflicts with Rule 408.
Right. I think husband's position is directly contrary to law. It's directly contrary to Rule 408, Murray versus Murray, and it tries to build in somehow that there was an offer, and as
it wouldn't be contrary to Rule 408 if you specified in your boilerplate that this will not be used, including to show the existence of an agreement, and both sides agree to that. Then it could be harmonized in theory. If you want to agree to something outside of 408, maybe you can do that. You
could agree to a confidentiality agreement saying, never, no way, no how does this come out of this room.
Sure.
We don't care what Rule 408 says. You could, by private contract, do that, right?
You absolutely could, but I don't know why you would in settlement negotiations.
Well, the question is whether you did, not whether you should have.
And I can avow to this court that, no, we did not. We never intended that, nor was there any consideration for that.
Subject, obviously, to, parties could agree to that. Whether it's enforceable or not is a different issue. If it undercut public policy, for instance, take the cases that deal with discovery and issues of public safety, like defective tires. Yeah, we'll disclose all this to you, tire company says, but you can't ever give it to anybody, including regulatory authorities. Courts don't have to enforce that. As a matter of fact, the rules anticipate they may not enforce it.
You could go the other way, too, right? You could have an agreement that says, here's a settlement proposal, Rule 408 is off the table. Use it as you will. And the parties could agree to waive the application of 408 for all purposes in a case, right?
I believe that is true.
Okay.
I'd also just like to point out for the record that Rule 2B, the family law rules, has not been invoked in this case. So there is even a question of whether all of the 408 language even needs to come in, because it would be admissible regardless.
Rule 2B is not a blanket application to the rules of evidence. And I admit you caught me off guard. Is 408 one of the excluded rules?
No.
Interesting. Okay.
Do you have any further questions for me, Your Honor?
Thank you very much, then.
Thank you.
And thanks to both counsel for your argument. This matter is now under advisement. The court will issue a written decision in due course, and we will stand in recess to allow the next argument to set up.